topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Tampa. Welcome to another Ask the Expert show where we bring you the top experts in the field of legal, health, financial, and home improvement. What a show we've got for you today. Hey, for the next 50 minutes, this is the last Tuesday of the month, and that means Kay Bender Rimbaum, our community association law firm, who has actually been with us for 12 years now. They have offices in Pompano, West Palm Beach, Tampa, and also in Orlando. This is our Tampa show today, and we have got one of the finest attorneys in the firm, attorney Kirsten Hens. Good afternoon, Kirsten.
Well, hello.
I am loving your hair color. I think you are definitely a blonde.
Appreciate that.
I didn't mean to. I'm really just trying to tell you how great you look with it. And, before we get started, I got to tell you, we get so many letters from board members who literally have their whole board together and listen to your show. And that's quite a compliment.
Definitely. No, I appreciate that. We certainly try to, prepare for the, questions to come as much as we can, and appreciate all the listeners out there.
Well, this is kind of the way to get free advice in a way, but at least it's coming from one of the finest community association law firms in Florida. We've got a few, things that you've got scheduled coming up that we'll be getting into. Before we get started, tell people about Kay Bender Rimbaum.
Sure. Well, the firm has been around for over 30 years. We started in South Florida, Pompano Beach, Florida. And we've, expanded over the years. I personally started in the Pompano Beach, Florida in 2010, and I've been practicing law 17 years. So I guess you can say I've been practicing community association law practically my entire career. But we are an exclusive.
Why did you choose community association law?
It was interesting to me. I started my career with a small firm, and the firm started dabbling in this area of the law, and I liked it. I thought it was interesting, and I searched for a firm that specialized in this area, and luckily, Kay Bender Rimbaum was hiring at the time. So the rest is history.
What a great fit! Yes, what a great fit. So, and people just should know there is so many things that a board needs a law firm representing them, isn't there?
Certainly. I mean, as most board members either know or should know, they sit on a board of directors of a corporation, a not-for-profit corporation, but it's a corporation nevertheless. And so they're not expected to know the ins and outs of operating a corporation, much less, all the laws that pertain to the particular, association, whether it's 718 or 720 of the Florida statute. And so, yeah, the board has to rely on its experts. And one of the experts is legal counsel. And that's what we do. We assist boards with the, with basically business operations.
Well, what we like to do and makes this show so special is we take your questions. The show for Tampa is once a month. We do an Orlando show once a month, and we do a Pompano, West Palm Beach show once a month. And we gather your questions. And you would not believe how many questions that we get. There's not enough time to answer all the questions. So we try to pick out the questions that are best suited, that a lot of people have questions about. So we're going to get started. We're going to start off with Frank and Brandon. He wants to know, do you need a permit to paint your condo building?
Well, that's going to depend on the municipality or the building code department in your area. So if you have any questions, I recommend just calling the building department in the area to confirm.
I got to tell you, I love this next question. I'm not laughing at it, I promise you, Wes. Wes in Tampa. He says, I live in a condo, and our so-called president, which tells me he's not too happy with this president, owns 20 units, and they are all full of cats, no people.
Right.
Each unit has 6 cats. Is that legal?
Wow, so 20 units and six cats in a unit, that's 120
in each
cats.
one.
Well,
That's
I mean,
a
there's
cat
nothing.
lover.
Yes. There's nothing in the condominium statute that addresses a limitation on cats. I mean, that's going to be something that's going to be very specific to this particular association. So I would look to the declaration of condominium to see if there is a pet restriction. And if there is, does the restriction prohibit cats? If not, then it's not likely a violation for the president to have cats in these units. Hopefully they're not causing a nuisance in the condominium, but that's a whole other issue, I suppose.
That's a mighty big investment for your cats, but hey, to each their own. We don't judge here. Let's go to Larry in Largo. Now, Larry, and thank you so much to the people who tell us if you're an HOA or a condo, that makes a huge difference. We've kind of trained everybody that, you need to tell us if you're an HOA condo. Larry is an HOA, and he wants to know, can we use general proxy at the annual meeting for voting?
Generally, yes, but really it's going to depend on the bylaws of your HOA, because with HOA, unlike the condominium associations, your election process has to be followed in accordance with your bylaws, right? So there is really no statutory process for elections. Every HOA has their own elections, which should be specifically set forth in the bylaws. And so you'll have to look at the bylaws to see, number one, if proxies are allowed in the community, and if so, if owners can vote at annual meetings by general proxy.
Joy in Tampa wants to know, I've never heard this question. What is a notice of commencement?
Yeah, so a notice of commencement is a document that typically goes with a construction contract. So in the state of Florida, if an association or an owner of a property is going to be doing certain types of construction work, whether it's roof replacement, concrete restoration, so forth and so on, they are required to file this document called a notice of commencement, basically letting everyone know, the public know, that work is being done. And if you are a subcontractor of the contractor, then you have to provide what is known as a notice to owner, basically letting the association know that, hey, I'm a subcontractor here and I exist. And so the association needs to make sure that these subcontractors get paid before they issue payment to the contractor to avoid double payment. And so it's a document that is executed by the board president. And there's certain information that the document requests, such as, what is the legal description of the property? What is the project that's being undertaken? It's going to request information about the contractor, to whom or to what address should notices be sent in connection with this contract. And then there's also information that you have to disclose whether the association is taking out a loan in connection with the project. So, many associations in the state of Florida have been forced to borrow money to fund some of these, multi-million-dollar construction projects. And so if you are borrowing funds, then you need to disclose the, lender and provide certain lender information. And then the notice of commencement will also request information as to whether the association is taking out a payment bond on the project. So typically with large dollar contracts, the board may elect to take out a performance and or payment bond. And a payment bond really is to ensure that the subcontractors and lieners do get paid, right? That the contractor doesn't run off with the money. And so if you are requiring the contractor to take out a payment bond, typically that gets recorded with the notice of commencement. This is probably way more information than the listener requested, but just so that they're informed of what this document is. Now, I will tell you, contractors will sometimes prepare these notices of commencement. In my experience, they're not always correct when they're prepared by the contractor. And so highly recommend that you have an association legal counsel review or prepare one of these notices of commencement and then have it recorded in the public records.
I notice we're getting a lot of questions, and you and I discussed this before the show. We realize there is a big bill coming out, but it hasn't been signed, and I promise you we'll have plenty of time to discuss it after it's signed, because it could change so many times. So all of you who have these questions about, and if you want to ask questions in the chat line, more power to you. It's fine, but we're not going to be talking about any new bills today. Let's wait till it gets signed, because it could change so many times. So we're not avoiding you, but if you have a question about this new bill that might be signed, we're going to hold off on taking any of those questions. We've got so many questions here. And listen, Kay Bender is so nice to give up an hour of their time each month to answer your questions. And you don't see that in very many markets. So let's go to Richard in Plant City. He is an HOA also. What is an architecture review committee, and what are they allowed to approve or disapprove?
Sure. So an architectural review committee is a committee that is typically set up by the developer. and you would find authority regarding the committee in the Declaration of Covenants, which is the declaration for HOAs. And it's essentially a committee that has the authority to approve or disapprove architectural changes to the parcel. Now, with new changes in the statute that took effect last year, there is the committee now can only approve architectural changes to the exterior of the home, not so much, inside within the home. But essentially, the declaration and sometimes even the bylaws will outline the powers and responsibilities of the committee. Essentially, if an owner wants to undertake a change, for example, whether it's replacing a roof or replacing windows, doors, or color change, they would have to submit an application to this committee, identifying what the proposed alteration is. Potentially even provide certain specifications prepared by a licensed contractor. And the owner might even be requested to provide additional documentation regarding the change, depending what it is. And so once the committee receives it, the committee typically will have a certain time frame within which to get together, review the application and the supporting documentation. And then depending on whether or not the documents authorize this, there could be some kind of deposit or some kind of fee associated with this application. And so, the committee gets together, reviews it, and then issues a determination to the owner whether or not this exterior alteration is approved. Now, some of the other changes to the statute that took effect last year is that the board or an architectural review committee has to adopt specifications, right? And so when reviewing an application for a change, it's important that there are specific specifications or standards in place as to, whatever it is that the owner is looking to change, because if you don't have standards or specifications, then becomes more problematic to deny a change, right? So for example, if an owner is looking to change the paint color, right? And let's say they want to change the color to, a dark beige, right? And let's say the board doesn't have specifications, doesn't have a color wheel on the colors that are authorized. Well, it becomes problematic to then deny this proposed color change, right? And so the committee's role, among other things, is to also adopt specifications and standards for, the various alterations that an owner could propose.
Shelley in Tampa, a condo. Can a president of our board hold more than one officer position? I don't think we've ever gotten a question like that.
Yeah, before. It generally yes, unless the governing documents would prohibit that, and that would apply really to an HOA or a condominium, because this is more pertaining to the corporate functions. So I would take a look at the bylaws, even the articles of incorporation, to see what positions an officer can hold. The one position that a president or a vice president cannot hold is the position of a secretary or an assistant secretary. So, president can be a treasurer. They just cannot be a secretary or assistant secretary. And the reason for that is because with corporate documents, such as contracts, typically requires the signature of the president, and then the secretary's function is to attest the signature of the president or vice president. So typically with corporate documents, you'll have two signatures, that of the president and then that of the secretary. And so you can't be, the same person can't be both president and secretary. So that's the only prohibition, unless your documents have something else.
Okay. Sherry in St. Pete, if our condo owner refuses access to a 6-year certification, what can be done? I don't even
So
know
I
why someone
presume,
would refuse that.
right. Well, you'd be surprised. A lot of owners, when it comes to requiring access to a unit, they can be a little bit challenging, right? For one reason or another. But, the association has an irrevocable right to access a unit for purposes of maintenance, repair, or replacement of the common elements or in emergency situations. And so if this is a certification that is required by the municipality or the county, then certainly the association has a legal basis to be in the unit, right? And so if the owner is not allowing access, I typically don't recommend for a board to force entry into a unit, by either using the key or, just forcing entry, breaking the lock and going into the unit, not unless it's an emergency situation. An emergency meeting, like unless there's an active leak, right, and the unit is being flooded. And the certification certainly doesn't sound like it's an emergency. So unless it's an emergency situation, my recommendation would be to proceed through the legal channels. And that could include sending an initial notice of violation to the owner, basically letting them know that the association needs access, and then give the owner a reasonable time within which to grant that access. And if that access is not granted, then potentially escalate it to legal counsel for legal counsel to send a more formal, firm demand letter. And if that still doesn't resolve the issue, then the association might be looking at pursuing a lawsuit, filing formal legal action against the owner to get access into the unit. And then, of course, if you're going to file a lawsuit, a more formal legal action, then there are pre-suit mediation requirements under 718. And so that's something that legal counsel can guide the association through.
We are getting ready to go to a break. Before we go to break, though, Kirsten, tell people about your upcoming schedule.
Let's see. Yes, we have in the month of May, with the few days that remain, we have a 7:30 class, and this is actually just in Palm Beach Gardens regarding the milestone and the SIRS, which is the Structural Integrity Reserve Study. That's more of a breakfast and learn, and it's taught by my colleague Peter Mullengarden in the Palm Beach Gardens area. Also on May 23rd, there is a condo board member certification webinar, and that is taught also by Peter and attorney Andrew Black. That's a webinar. On June 4th, in the Weston area, which is in South Florida, Michael Bender, which is one of the named partners, he's going to be conducting a legislative session update. That one is in person, but then on June 17th, there's going to be a similar legislative session update via a webinar. Okay, so that's also going to be taught or discussed by Michael Bender. So those of you that have questions about the new legislation coming down the pipe, then this is something that you might want to attend. Then June 24th, I'm actually teaching a condo board member certification webinar with my colleague, Alan Schwartzide. And Alan, for those of you who listen on this show, would know that Alan is in the Orlando area. And then lastly, on June 26th, I'm actually teaching a webinar for the 2025 legal update. So this is for changes that took effect July 1st of 2024. But for those who are still looking for those credits, that will be on June 26th via webinar. So
First of all, give everybody the phone number to reach your office.
Sure. So the main office number is 954-928-0680. And that is the main number for the Pompano Beach office. But if you call that number, our call center basically will redirect your call to the specific office. So
we are going to go to break, and I promise you, Bonnie, who has written us a question for you, it's a good question. We're going to hit that as soon as we come back from our break. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. This is the K. Bender Rembaum Community Association Law Firm Hour. We have Kirsten Kins with us. She is one of the attorneys in the office. She handles the Tampa office, which is a great market. This is the last Tuesday of the month is when she comes on with us, and we have so many questions that we're going to get to with you. Rich in Tampa, I love your show. This has got to be one of your cousins, Kirsten. I love your show. Thank you for all your great information. Special assessments passed, and then we got another special assessment right on top of it. I checked the company out, and the construction company doesn't exist. She actually went into great detail, all the work she did to try to find out who this company was. What can I do to find out this company is for real?
That is a good question.
Yes.
Well, there's two sources that I'm not sure if this listener has tried out, but first you want to try to locate them under the Division of Corporation website, which is sunbiz.org. So every corporation that conducts business in the state of Florida should be registered with the Division of Corporation. And so when they have registered, and by the way, this includes foreign corporations, meaning corporations out of the state of Florida, right? If you want to conduct business here, you need to register with the state. And so if they are registered, then if you go on sunbiz.org, there should be a link there for search the entity. And then you type the name of the corporation and they should pop up. Now you have to be careful. You have to use the correct full name of the corporation, or at least, the first, 2 or 3 words in the name of the corporation. If you don't type up the correct words or names of the corporation, then you're not going to be very successful. And then hopefully that will give you the results you're looking for. Otherwise, you can also look up on the website of the DBPR, and that website really should even disclose the license number of this construction entity. You could even try calling the DBPR to see what they can, what additional information they can provide.
Okay. What can a member do to get the ARC to enforce a violation? The ARC states it will not be enforcing certain violations like running a business out of your home or not following color book HOA.
What was the first part of of that question?
What can a member do? There you go. What can a member do to get the ARC to enforce a violation?
Well, first you need to confirm if the ARC committee even is authorized to enforce violations, right? So the ARC, remember, in responding to another listener's question, I said that the ARC is typically given the authority to review and then approve and disapprove architectural changes. Whether the ARC committee has the authority to then enforce any violations, I mean, you'd have to confirm that with your governing documents. Typically, that is a function of the board. One of the violations that Bonnie noted in the message was a violation involving running a business. Right. So those are types of covenants that are not typically a function of the ARC committee to enforce. That's more of a board function, right? So I would again default go back to the declaration and bylaws and just confirm the authority of the ARC committee. But whoever has the authority, and typically the board, to enforce this, it is a breach of fiduciary duty if the board does not uniformly enforce covenants in a timely and a uniform fashion. And so if the board is not doing their job, then you can send them a letter, basically let them know, that they're not doing the job. And if not, then I would suggest get legal counsel involved.
Okay. Lawn in Tampa, this is a condo, Kirsten. They have 145 units. They want to know, do we need a CSRS reserve fund? Our building is 2 levels.
So 2 levels, I presume he means there are only 2 stories, or just under 3 stories. Well, the
Yes.
CSRS, or the Structural Integrity Reserve Study, that applies for condominiums that are 3 stories and higher. So it's not so much dependent on the number of units within the condominium, but more of, how many stories. And it's currently set right at 3 stories or higher as determined by the building code. So if you're under 3 stories, then you would not be required to have a CSRS.
Okay. Shelley in St. Petersburg, a couple bought into our association. Our board rules, our bylaws say for a 1-bedroom is only for 2 people. Can an additional family member stay over 6 months, making it 3 people? Can we enforce our bylaws?
Okay, so hopefully this is a restriction that's actually in the declaration of condominium and not in the bylaws or in the rules. It's not unusual to see limitations on the number of people that can occupy a unit. If you have such a restriction, take a look to see if there are exceptions. It's not uncommon for these restrictions to allow, guests and visitors to occupy the unit for a certain period of time, or there could be some exceptions granted. If not, then generally, these occupancy restrictions can be enforced.
We get a lot of questions, and I've learned from your show. I could even answer this myself, but this is John and Brandon. Is an inhabitable garage considered the first story of a building? We were just talking about the 3 levels on up, but some people have a garage. They want to know, is that part of the amount of levels?
So I would have to defer to an engineer, because the way the statute is written, it does say the SERS applies to condominium buildings with 3 stories or higher, as determined per the building code. And so, unfortunately, I'm not an expert in the building code, so that can only be determined by an engineer.
Okay. Lori in Tampa is changing to a metal roof. And for some reason, Kirsten, we get a lot about metal roofs. Is changing to a metal roof on a condo a material alteration, or would it be a board vote without the community?
Yeah, that's a good question, but material alteration is basically an alteration to the exterior of the condominium. And in this case, it sounds like the association or the board is considering replacing their existing roof with a metal roof. If that is
Yes.
the case, then yes, it would be considered material alteration. The division of condominium would certainly consider it an alteration. Now, whether or not you need a membership vote, or this is a board vote only, will depend on your declaration of condominium. So, Chapter 718 of the Florida statute currently provides that unless otherwise provided in your declaration, you need a vote of the membership, which is 75% of the voting interest. So that means you have to look at your declaration to see if you have a different approval requirement. And you could have something less, majority or 2/3 of the owners. You could have even a dollar threshold. So the association can spend up to a certain amount of money on an alteration, and anything beyond that would require membership approval. So it really depends on your declaration.
Okay. We're also starting to get, I bet you're getting these in your office, questions like people are very concerned about investors taking over. Mark in Tampa wanted to know, what can we do to stop investors from taking over? Can we put a limit?
Well, and investors, I presume, are buyers that are buying multiple units and then are renting them out, essentially, right? So they're
Yes.
not permanent occupants. Yeah, I mean, there is a lot of concern, because when you're not an owner that is permanently residing there, or most of the time, right, then that creates a lot of transiency. And so that could be problematic. There are ways that a board can control investors, and one of them is to prohibit or limit corporations and other entities, such as a limited liability company, from purchasing units. So that is a provision that we, in fact, have enforced many times on behalf of the association. So that's one option. Now, you would be grandfathering in, if you do propose such an amendment, you would be grandfathering in anybody, or you should be grandfathering in any entity that has already acquired title to the unit. So you're not divesting anyone of title, but rather just going forward, no new entities or corporations can purchase in the community. So that's one option. Now, you would also exempt association from that prohibition. And the reason is because the association has the ability to lien and foreclose if an owner doesn't pay assessments. And so if the association forecloses and takes title to the unit, well, obviously you want the association to be able to do that and not preclude that. Now, another option is to propose an amendment to the declaration that limits the number of units that any entity or any owner can own, right? So going forward, no more than 1 unit or no more than 2 units can be purchased at any one time. Again, you would be grandfathering in or letting existing owners to keep their multiple units, but once they start selling them off, they're not allowed to buy any additional units. So that's another way that you can curb investors.
Could you stop them from saying they can't rent the unit out for the first 2 years? You can do something like that.
Yeah, that's called, that's referred to as a lease moratorium. So essentially, once the purchaser takes title to the unit, you would prohibit them from leasing for a certain period of time. And typically it can be 12 months, 24. I've even seen it up to 36 months from the date of acquiring title. Yep.
You know, I gotta say, as long as we've been doing the show, it seemed the first 3 or 4, even 5 years, God, we got so many questions about pets. Um, and we don't seem to get that many questions anymore. But here's one from Jack in Tampa. He said, my condo docs nor rules and regulations prohibit pets. Our board has denied an ESA dog to one of the owner's renter. Can the board suddenly add in the rules and regulations no pet restrictions?
Well, that is problematic to do so. And the reason is because pet restrictions, among other restrictions, should really be contained in your declaration of condominium, right? That is the document that contains your use restrictions. And so in Florida, when a board is looking to enforce a rule, let's say in this case, this pet rule, one of the things that a court will look at is, well, they really do a three-prong analysis on the enforceability of a rule. One of them is, does the board have the authority to adopt a rule, right? And presuming that the board has the authority to adopt rule. The second prong is that the rule cannot conflict with the declaration. And that means expressly with an express provision in the declaration or by inference. So if the declaration is silent on a particular restriction, then under the law, the implication is that that particular issue is not restricted, right? So if the declaration is silent on pets, that means that there is no restriction on pets. If the board then goes and adopts a rule prohibiting pets, that is a direct conflict with the declaration that doesn't prohibit pets. Right. And so enforcing that type of rule could be successfully legally challenged by the owner. And so if the board is really looking to prohibit pets, they really should consider adopting an amendment to the declaration, which, will require membership approval. So it should be done by amendment, not so much as a rule.
Okay. Jenny in Tampa. Can a board refuse to Zoom a meeting to avoid having to record it?
Well, that's an interesting use of the word Zoom, to Zoom a meeting. Now it's a verb.
Yes.
Well, there's really no requirement for a board to conduct meetings by Zoom. Board members, can offer Zoom as an option, but there is no legal requirement for them to Zoom. And so if the board chooses not to Zoom, that's totally acceptable. There's also no requirement under the law for a board to record a Zoom meeting, right? And so that is completely within the board's discretion.
Jill in St. Pete wants to know, our board refuses after repeated requests to enforce our rules and regulations. What can we do about it?
Well, I mean, I think it's same answer as the one I gave a few minutes ago with the ARC committee, right? A board has a fiduciary obligation to enforce covenants and rules and regulations in a uniform fashion. And so the failure to do so could be potential breach of fiduciary duty, right? And so, you can send a letter to the board, basically, stating they haven't enforced a particular rule or a covenant, and that you expect that they would be doing so. Absent, if the board fails to do that, I suggest getting legal counsel involved and trying to resolve this with the board.
Okay. Larry in St. Pete, how much time do you get to spend a special assessment? What happens to leftover funds from a special assessment?
Well, there's no specific time frame set out in Florida statute about, a time frame within which you have to spend the special assessment. Obviously, you'd be adopting a special assessment to cover, funds for a particular project or a budget shortfall. And so you basically, use those funds as long as you have them, as long as the project lasts and your payment obligations exist, right? Once the board has paid off their obligation, whatever it might be, whether it's a contractor or whatnot, if there is any leftover from the special assessment, then typically, unless your documents provide otherwise, that would be considered a general surplus, which basically is operating funds that the association can apply to any bona fide association expense.
Chris in Tampa, I don't know, is COA community association or is it condo association? I don't know. COA.
HOA, community association. Well,
Well, I'm trying to figure out if this is HOA or if it's condo, but it says a COA board voted on and signed a contract with a contractor to complete the multi-million-dollar concrete restoration project over the next 2 years. Can members petition to stop the work? I guess it doesn't matter if it's HOA or condo.
it doesn't, right? But it would be a condominium association. I mean, typically, no.
Okay.
It's a board decision to enter into contract, and so under these facts, very unlikely that the membership can basically force a termination. I mean, the members can always petition. The question is whether they can force a termination of this contract. And depending on the facts and the circumstances, the board may or may not have a basis to terminate the contract. And if they do, you've got to be careful because typically there are termination clauses in these construction contracts that would require the association to pay a penalty. And those typically can be, a lot of money. So I would suggest if you get such a petition from the owners, definitely speak with legal counsel.
Before we've got a few minutes left, let's go through your schedule again coming up.
Sure. Let's see here. May 29th at 7:30, there is a breakfast and learn regarding the milestone and the SERS requirements, and that's in Palm Beach Gardens. On May 29th at 11 o'clock, we also have a board certification, a condo board member certification webinar. June 4th at 6:30, we have a live in-person event in the Weston area, and that is on a legislative session update with Michael Bender. June 17th at 1 o'clock, we also have a webinar also on a legislative session update. June 24th, I'm teaching at 11 o'clock the condo board member certification class with Alan. And then on June 26th, from noon to 3 o'clock, I'm teaching the 2025 legal update for credit. And that's for laws that took effect July 1st of 2024.
And let's finish out by giving everybody the phone number and the website how to reach your office.
Sure. The website is kbrlegal.com. And if you go on the website, there is our schedule is posted for the month. So you should be able to click on a specific date and register for a specific class. And then the main office number is 954-928-0680.
Kirsten, as always, you do such a great job representing K. Bender Rimbaum. We love doing the show with you. We will see you next month. Thanks so much for stopping
Sounds
by
good.
today.
Thank you.
Thanks, Kirsten.
Okay.
And that'll do it for us today. That's the K. Bender Rimbaum. We might as well just call them the K. Bender Rimbaum Hour that we do. That's it for us today. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.